Rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our first case is James H.Q. Davis Trust et al. Versus JHD Properties LLC et al. And we will hear from the appellant.
May it please the court. Chief Justice Newby, Associate Justices of the North Carolina Supreme Court. My name is Joe Nanny. I'm a member of the Wake County Bar. It's my privilege to represent the Charles B.Q. Davis Trust in the litigation that brings us here. Your Honors, this case began because the plaintiffs want to dissolve two LLCs. They're North Carolina limited liability companies that are owned by four brothers. There was a Dr. Davis here in town who was a cardiologist. As part of his estate planning, he created four trusts, one for each of his four sons. He created the two LLCs, which hold real property here in Wake County. When Dr. Davis put those trusts together, he created operating agreements that are exactly the same for the two LLCs. So we use them interchangeably when we talk about the farm LLCs. It's two LLCs, but they should be treated the same because they're basically identical. What happened was that when the LLCs were created, he gave the four interests to the four trusts of his sons. He created two managers. One son is Jim Davis, the other son, my client, Chuck Davis. They're the two managers of the two LLCs. And the operating agreements provide that the LLCs can only act if there's a majority agreement of the managers. So as a practical matter, unless the two managers agree, the LLC cannot act. The plaintiff, Jim Davis, through his trust, brought this claim contending that the LLCs should be dissolved because they can't operate. As your honors know, the LLC statute gives very little guidance as to when dissolution is appropriate. All it says is the Superior Court may dissolve an LLC if it is established that it is not practicable to conduct the LLC's business in conformance with the operating agreement and the LLC Act. Your Honor, what is not practicable? The North Carolina appellate courts have given us basically little guidance to this point as to what that means. And as you saw, the lower court in its decision relied on cases from other states using similar language to try to determine what it means to be not practicable. But I want to take a step back from that. The question is, what's the business of these LLCs? LLCs were formed in the early 2000s, and for the last 20 years, they've operated a timber forestry business. When we say business, for the most part, that timber grows on its own. There's very little management that needs to be done to it. It's not like somebody's out there every day dealing with it. But that's what the business of the LLCs historically has been. Both Chuck Davis and Jim Davis have filed documents with
Before you go on, may I ask one question? I understand that the motivation for the forestry is for taxation. How does that affect your analysis, or how should we view that as far as the business of the organization? Because there's certainly, your friends on the other side may make another argument, and I'd like to go ahead and hear your part.
Sure. And the fact is that there's been no timber harvested since 2004. We understand that. But that doesn't change the fact that they hired a forester. They put a forestry plan into place. That plan expired in 2022, but it was there. Since 2000, the managers have said publicly and to each other, they agree they need to hire a new forester. They should have a new forestry plan, and it is probably time to do a timber harvest. So the fact that nothing has happened actively doesn't change the fact that it is a business.
All right, and then one follow-up. My understanding from reading the documents that only one of the parcels was affected by the agreement, the forestry agreement. How should we view that?
The forestry plan was only, that's exactly right, it was only for one parcel of the property, but the parties have always treated the property all the same. They haven't treated them any differently. The fact that there wasn't a forestry plan in place should not change the fact that it was used for forestry, intended to be used for forestry. In fact, both LLCs filed annual reports with the Secretary of State where they represented that their business was forestry.
Thank you.
With regard to the forestry business itself, there's never been any disagreement between the two managers over anything. I mean, they've completely agreed how they want to handle it, what they're going to do with it. There's a lot of inertia in this case, right? They've talked about hiring a new forester, but they haven't done it. They've talked about a new forestry plan, but they haven't done it. The court below found the inertia or the lack of activity to be a basis to find that there's a deadlock. We disagree. We don't think that's what those facts show. What they show is inertia, some uncertainty among the managers about what they want to do, but not a deadlock. And we believe that the standard of not practicable, you've got to find evidence that shows there's, not that it's impossible to move forward, but that it's clear that they can't move forward.
So I understand your argument, but that is not how I read the trial court's order. So help me understand why we should focus on that and not what I thought the trial court seemed focused on, which is the idea that a developer came to the businesses and said, I'm willing to buy this land and here's what I'll pay. And the critical question would then become, if we look at the present value of all the expected returns from what we're doing with the property now, the forestry and so on, if we imagine the expected return, the present value of if we developed it ourselves, if we hold on to it expecting appreciation in real property and then develop it later, if we think of all those things and what this developer is offering is more than any of those other options, we would sell the property. That would be in the best interest of the owners. And when that offer was made and one manager said, I'd like to negotiate because we need to know, are we going to get that kind of an offer? The other manager said, here's my offer to buy you all out, and that's the only thing you're going to hear from me. And it was that deadlock that led the trial court to say, this just can't continue as a going concern. It's dysfunctional. So what's the response to that?
Well, first of all, I don't think that shows a deadlock. I think your description of what happened is exactly right. There's one other piece to that, which was that Jim Davis in his deposition testified that when that occurred, he gave the developer Chuck Davis's telephone number. He gave Chuck Davis the developer's telephone number. Neither called the other. If the developer wanted to pursue this, he could have called. Now, the fact that Chuck Davis didn't call suggests maybe he didn't want to do that. But again, even if there's a disagreement about this one offer, because that is the only offer that's ever been made on the property, I don't believe that gets us to a deadlock when you look at it in the context. Because when you look at it in context, what we have to look at is what have the managers said to each other over time? And this is what I wanted to talk to you.
Just to clarify, the trial court made a finding that that you have one manager saying, authorize me on behalf of the business to negotiate, and then the other manager not responding to that.
Correct.
So even if what you're saying is true, I mean, they could reach out individually, but you would, it's only the business that could really negotiate. And I think what the trial court found is, well, the business could not get the necessary authorization because there's only the two managers and they're just not actually agreeing on anything. And so what do we do about that?
Well, I think that that's one instance, and I don't think that one instance creates a deadlock overall. And again, I want to go back to the context, if we may. 2007.
Well, and before you do, you say this is one instance. The other instance or other situation that I think plays into this is the fact that Chuck Davis, I believe I've got the right name,
Yes, ma'am.
wanted to buy the property and on two different occasions offered up a proposal that just fell on deaf ears. I see that also as a potential deadlock, or at least the trial court did. How do you answer that?
That's completely correct in terms of that has not gone on. It's interesting because in his deposition, what Jim Davis said was he thinks he's still willing to sell to Chuck. He just hasn't done it yet. He didn't like the proposals that came before because they weren't firm proposals. They were letters of intent. What Jim Davis says is he didn't want a letter of intent. He wants an actual firm offer. Again, I don't think that's a deadlock. I think it's just they haven't reached the point of getting to that offer.
Remind me, I understand your point about he may still be willing to sell to him or work this out. But my recollection is there really wasn't a response to either of those proposals. Am I misremembering?
No, there was a no. I mean, there was
Just
a no
no,
at one point, but
but
nothing.
no counter.
No,
Okay.
no, nothing beyond that. But again, I want to go back, Your Honors. 2017, 2018, the operating agreements say the members have no right to control the business at all. In 2017 and 18, the two members who were not the managers wanted to sell the property then. There was no deadlock then because Jim and Chuck agreed we're not going to do it now. All right. If you read the record, what the judge below said was that Jim has always wanted to sell the property. Well, that's not true. In 2020, Jim sent an email to Chuck, and this is in the record, where he said, not during the pandemic, we're not going to sell it now. So what you're going to see if you look at the complete record is they're shifting positions by the managers because in part they don't know what they want to do. All right, they're both considering other options as to how they're going to either develop or dispose of the property. The fact that they have not reached a conclusion of that, I'll contend to you, is not enough to get you to a deadlock. So 2017, 2018, they're in agreement, we're not going to sell it. 2020, Chuck says, I don't want to sell. I'm sorry, Jim says, I don't want to sell it. Chuck says, okay, you're right. But in 2018, Jim participated in meetings with Chuck where they hired consultants to go out and examine the property to figure out how they could develop it. Jim said at the time he was excited about developing an agritourism business. In 2020, Jim sent an email, I have an open mind on a development plan and eventual sale. The following month, Chuck sent a lengthy email to his co-manager asking for the co-manager's thoughts on a plan for moving forward with development. In that email, he says, if you have other specific ideas on a reasonable path forward, please share them. I'm happy to consider them. Jim responded that he's open to engaging an engineer to determine what the property could be used for. In January 2021, Jim told Chuck he was willing to sell his interest to Chuck. And you have to understand there are periods of time, months at a time, where there's nothing going on. And I don't think that inertia should be viewed as anything other than just that. They both have busy lives, they're doing other things. But when you look at the actual communications that they have with each other, they're cordial. At no time has either manager said, I'll never do that, or I refuse to do that. Because we're talking about the death knell for the LLCs, if you dissolve them, they're done. I think the standard has to be a whole lot higher than, well, you haven't gotten there yet. All right, the plaintiffs are going to contend that the temporal element of this, because they haven't reached an agreement in so long, is enough to find a deadlock. I don't think that's true. I think particularly in the context where over the past 5 or 6 years, both of the managers have offered different ideas for what they want to do. No one has taken a firm position of, I will never do this.
But what I understood the trial court to be reasoning is it's more than just sort of the length of time that nothing was being done. It was this critical event that happened, which is that the primary purpose of a business like this that's holding real property is to make money off that asset. And so one of the most important things you need to do is if somebody wants to buy the property, you need to know how much they'd be willing to pay for it. So you can do the calculation of, is now the best time we'll ever have to sell. And that when that event happened, the business couldn't perform that one core function, which is to negotiate about the maximum price that that buyer would be willing to pay. And that missed opportunity demonstrated if the business can't even do this, the deadlock is so severe that it's not practicable to remain as a going concern. I mean, that was what I understood the reasoning of the trial court.
And I think that's right, Your Honor. I think that is what the trial court said. And what I'm saying is, I don't think that's correct because I think you're looking at a microcosm. These relationships have gone on 20 years. The fact that something didn't happen in a 1 or 2 month period is not determinative of the relationship or whether or not the business can move forward, particularly given all of these communications back and forth between the managers where they've said, oh, well, let's think about this. Let's talk about this. It's not where they're just refusing to deal with each other. So to go back to the history a little bit more, Jim told Chuck in January 2021 he was willing to sell his interest to Chuck. In October of 2021, Jim and another brother, Tad, sent a letter to Chuck offering to sell their interests. Now, they didn't go anywhere, but the point being the communications continued to be, let's find a way to move forward. In April of 2023, which is almost a year after this lawsuit was filed, Chuck sent information on a possible avenue to develop the property, and Jim's response to that was to ask for more information. He didn't say no. He didn't say we're not going to do that. He asked for more information. Jim testified in his deposition he's not opposed to a development plan, but he wants to sell to the highest bidder. I don't think taking all these interactions as a whole, that's a deadlock. I agree that the one developer, that didn't happen, right? There was no movement on that offer to get it sold. But if you look at a 20-year history of the LLCs, I don't believe one failure to come together amounts to a deadlock that the LLCs can't move forward. And
Allow me to follow up with Justice Steed's question with the pivoting just a bit. Looking at the statute, we talk about whether something is practicable or not, and that is determined by both the conformance with the operating agreement and, of course, North Carolina LLC law. And so what that really means is that we look very closely at the operating agreement. So in some respects, this drills down almost into a contract case. And so on the first page of the operating agreement, the purpose and business of the company shall engage in the purchase, development, rental, ownership, and sale of real property. And so that gets to the point that Justice Dietz was making, but I'd like to step back really to the earlier question that I asked, or in the context of that, the trial court's order actually referenced some tax law about how important, by analogy, how important it is to have an active organization or business as opposed to a passive organization, and used as an example, only by analogy, a tax situation, a tax case that indicated that just forestry was not an active situation. Also, if you look at North Carolina, and this was not argued, but just as a general concept, if you look at North Carolina partnership law, in order to have a partnership, you have to have an active business there. So help me understand how, even in the context of this, if we say, okay, in this one situation, we don't have deadlock necessarily, but what is your position that the purpose of this operating agreement is actually being fulfilled, even taking that aside?
I think the fact that for 15 years everybody was satisfied with it demonstrates that this is a new problem. This is not a problem that began when the LLC began. The fact is everyone was fine with just having the timber business for 15 years. It's only in the last 3 or 4 years that issues have arisen because now they do want to sell the property. And you're exactly right. The operating agreement certainly recognizes that selling the property is one of the business purposes of the LLCs. My position on all of this is because they haven't done it yet, that doesn't lead to the conclusion that they can't do it or they're incapable of doing it. And my evidence that supports that are the things we were just talking about, their interactions with each other. The managers have said, I'm willing to consider this. Let's talk about this. Maybe we'll do this. All right, there's a single incident where a sale did not go through. And that's exactly what the trial court hung his hat on. I mean, that's where the court came down. Our position is that's not enough. That if you're going to dissolve an LLC, it takes more than one instance of the parties not completing a transaction in order to reach that point.
Can I also ask you about the purpose of the LLCs here? Because the purposes clause doesn't explain to what end. In other words, it says that it's to purchase, develop, rent, own, and sell real property. But there could be, I guess, is there anything in this agreement that suggests that maximizing the dollar value at any particular time is the end goal of the agreement? It seems to me that holding real property, there could be lots of other purposes. They could want to conserve it to have a natural area. They could want to make sure that their descendants have a connection to the land that their father purchased and bought. It seems to me there could be a number of different end goals that it is up to the managers to decide, to what end they are engaging in purchase, development, rental, ownership, and sale. And is there anything in the operating agreement that specifies exactly, ultimately, what their end purpose is supposed to be?
No, and you're exactly right, Your Honor. The language in the operating agreement is fairly broad, and I think it's clear if you read my client's affidavit. He wants to do exactly that. He wants to protect the land. He wants to keep the land. He doesn't want to sell it. But he's not said he won't sell it. He's never said he won't sell it. He put an affidavit in front of the trial judge that says, I have never said I won't agree to sell the property. But that's not what he wants to do. But back to your question, the operating agreement itself is very broad. It doesn't say at all what you're going to do with the property.
But isn't the default that you're maximizing the value for the owners of the business? So for example, imagine that your client was the sole manager and that, you know, he had these other owners of the business were minority owners. So your client had, and just said, well, I think the purpose of this business is to hold this property in environmental conservancy. And there was a lawsuit. I mean, your client would probably lose that. The point is, given the language of this operating agreement, it's understood that you're doing all these things in the, you know, to maximize the value of the owner, the business for the owners.
Yes, I don't disagree with that at all. And in fact, what my client wants to do, and this is in the record, is he's presented these proposals because he believes that developing the property, and particularly for an agritourism business, is in the best interest of the LLCs and of the members. And they are in disagreement about that. I'm not going to sugarcoat it, but again, neither manager has said, I won't go the way you want to go. They just have continued to talk to each other and have not yet reached a resolution. Your Honors, I failed to reserve time. I'd like to reserve 5 minutes, and I apologize for not doing that at the beginning of the argument. But to sum up where we are, when we look at the cases from other states, it appears to us that that dissolution is found to be appropriate basically in three different buckets, if you will. One is if the business can't operate. All right, Judge Bledsoe in his order cited the G.R. Berger case. That's where the manager was convicted of tax fraud. They had a contract with Caesars Entertainment. Because Caesars would be in trouble with the Nevada Gaming Commission, they terminated the contract. So there was nothing left of the business. Okay, well, of course, dissolutions make sense because there's nothing left of it. The second situation is where one member, one manager is getting all the benefits and the others are not. They're being deprived of their benefit of the bargain, basically. And the courts have found that's appropriate to dissolve in that instance. And then the third, and our case is not either one of those. The third one is whether there's a deadlock. And the question I think before you is the communications, have the communications that have been between the brothers reached the point that it is a deadlock? Mr. Gaston is going to tell you it absolutely has, and my contention is that it has not. And it's important that if you look at the evidence as a whole, we think that the trial court erred in entering summary judgment, and that the appropriate thing to do would be to either reverse and find this is not sufficient to have a dissolution and therefore enter summary judgment for the Charles B.Q. Davis Trust, or at the very least, look at these communications and come to the conclusion that there are genuine issues of material fact for which summary judgment should not have been entered. In the one case where this court gave guidance, in the Campagna case, Chisholm versus Campagna, you affirmed dissolution of the LLCs, but you noted that the trial judge relied on his observation of the parties during the course of the trial, and that he had heard extensive evidence concerning the level of animosity between the parties. Well, the trial judge here denied himself that opportunity by ruling on summary judgment. We think that if dissolution is even a possibility, that the case should go to trial. The trial judge have the opportunity to hear the parties, see what they have to say, see how they interact, before making the determination that they have a deadlock that would result in the dissolution of the LLCs. Thank you.
Counsel? We'll hear from the FLE.
May it please the court, I'm Ed Gaskins with the law firm of Everett, Gaskins, Hancock, Tuttle, and Hash. Appearing here with me this morning are my colleagues James Hash and Andrew Simpson, and Mr. Hash will also participate in the argument. I'd like to reserve 5 minutes for him, and he'll deal with the issues that were raised in the amicus brief, and hopefully I'll be able to deal with the other issues. The matter before the court today is not a matter of my opinion or opposing counsel's opinion. It's a question of the court's opinion as reflected in the summary judgment order. This is a case about a statutory remedy which was created by our General Assembly, and it's a remedy which is specifically incorporated into the operating agreements. Section 10.1 specifically notes that one way in which the LLCs can be dissolved is by a judicial dissolution. The language of the statute is interesting, and it's really in two parts. It requires two different decisions by the judge. Part 2, Part 2 says that if it's established that it is not practicable to conduct the LLC's business in conformance with the operating agreement, the court may enter an order of dissolution, because the predicate for the entire statute is the Superior Court may dissolve an LLC in a proceeding brought, so forth. So the court has to determine, and did determine, two things. One is that he had the power to dissolve because there was a management deadlock, which resulted in impracticability of operating the business of the LLCs. And secondly, he chose to exercise his discretion to actually enter an order of dissolution. Now, because the way the statute is worded in terms of the business of the LLCs, as this court has already noted, it became important for the court to determine what the business of the LLCs is. And in fact, I think we've had questions here already. Well, how do we determine what this business is? Well, he actually used two factors, two uncontested facts to support his determination. The first of these is the uncontested fact that these LLCs were created for estate planning purposes. And I believe all of us would acknowledge that the primary purpose of estate planning is for a father to leave the benefit of his fortune to the sons, and that was exactly how these trusts were created. The beneficiaries of the LLCs, the members of the LLCs, are the four trusts. The sole beneficiary of the trust are these four sons. And the second thing that the court looked at was the actual language in the operating agreement. And what is that language? The section is, this is section 1.5A. Section 1.5 is labeled purposes and business. And it says the purpose and business shall be, that's a must, shall be to engage in the purpose, purchase, development, rental, ownership, and sale of real property, and anything else you want to do. So it's pretty clear what the intention of Dr. Davis was, and all of those 5 elements actually describe what is involved in a real estate business. If you own real estate as a business, then you're involved in the purchase and sale and the rental and ownership, and as the court has already said, isn't the purpose of that to try to maximize value?
But it does say any other lawful business.
Yes, and that's included in every operating agreement I've seen, just so that you're not limited. But it tells you first, the first thing it tells you is what the creator intended it to do, and then it gives permission to do anything else. And let me illustrate, if I may, the difference between a real estate business and owning real estate. And these are the factors that are involved in a real estate business. My wife and I own real property here in Wake County. It's our home. We've owned it for 38 years. I will tell you, in that time, we have never considered rental or development, and we've seldom considered sale, because we're not in the business of real estate. It's a home where we raised our children and hopefully where we can stay as long as we're able. On the other hand, at one time, I was a member manager of an LLC that purchased property in Cary, North Carolina. And I will tell you periodically, as I remember it, it was about quarterly, we considered, should we develop it? Should we rent it? Should we sell it? Because we were in the real estate business. And if you're in the real estate business, you must do those things constantly. You must determine what is the best advantage here. Do we hold on to it, or do we develop it or sell it? And that is actually what went on for a long period of time. That is, the managers agreed until 2018 that the best use of the property was to hold on to it. The court beginning on in paragraphs 10 through 18 talks about what happened after they disagreed. And it runs through the events that occurred between 2018 and 2022. It says in 2018 or 19, the managers decided that they needed to do something with the property. And they had a number of proposals that went back and forth for years. They finally got to 2020, and they decided at the beginning of the COVID not to sell. And then they changed their mind and decided it was time to do something again. And Jim Davis thought that the thing to do was sell, and Chuck Davis didn't agree with that. In fact, there's a footnote in the opinion, footnote 52, that says that Chuck Davis' position is that as a manager, he isn't even obligated to consider a sale. And the court raises, well, doesn't that raise some fiduciary duty issue? But that's been the problem here, is that Chuck Davis, Charles Davis, doesn't even consider it to be a duty to consider selling this property. And when an opportunity to sell it did come, he went in competition with that offer. He made himself an offer.
Your friend's best argument is that this was one discrete event. Yeah. And there actually is some case law from the business court that suggests that kind of discrete event isn't enough to say there's a deadlock. So what's different about what happened here versus these other cases where you just had one disagreement like that?
The dispute actually arose in 2020, and it continues today. Chuck Davis has said he wants to buy the property, but to this day, he's never made an offer to buy the property. The most he's done is said, well, I want to negotiate. I'll give you this letter of intent, and we'll talk about it. And my client has said, basically, I don't trust you. If you want to buy the property, make an offer, and I will consider it. And he has not made an offer to this day, 2024. So it's been 4 years. But they really started the dispute. Judge Dietz, if you look at the order itself, in 2018 or 19, they have not been able to agree on the proper disposition of the property. So it's not just this one event. That was the event that triggered the lawsuit. It's been the continued inability to decide what to do with this real estate business beginning in 2018 or 19. And furthermore, the court, in its determinations, based on the facts, the uncontested facts, says, I don't see any way to resolve this. I just don't see any evidence that the managers are moving together on this. If there is some evidence, it was not presented by the defendant, and that would be his burden. Of course, the court explains what happens in summary judgment. We came forward with all the evidence we knew to support dissolution. And most of that evidence, it turned out at the end of the summary judgment period, was uncontested. And the burden was on the defendant to bring to the attention of the court all the evidence that it had in this case to defeat dissolution. And it came forward with nothing to suggest that this matter could be resolved because of the insistence on Jim that the way to proceed would be to sell, and the refusal of Chuck either to make an offer to buy or to permit Jim to deal with a third-party owner-developer who had put a proposal on the paper that needed to be negotiated.
So is your argument then that there's a deadlock because there's only one outcome it appears that would be acceptable to Chuck Davis, he won't take the steps necessary to make that outcome possible, and he won't allow the LLC to consider any other outcome.
Yes, Judge Allen, Justice Allen, that's correct. It is. And there's a similar problem with the forestry. In paragraph 8 of the order, the court sets forth the uncontested facts concerning the, quote, forestry business, end quote. And here are the 6 elements, uncontested facts that the court points to. First of all, everyone acknowledges that the reason that they went into the, quote, forestry business was tax benefits, as the court has already noted. Secondly, they've made only one timber sale since 2004, a timber sale once in 20 years. Thirdly, only one LLC is involved in the forestry business. Third, they permitted the management plan, which started in 2012, to expire in 2022 and has not been renewed. Thirdly, fourthly, in depositions, both of the managers said they would be willing to consider hiring a forest manager and cutting timber, but they've never entered into any negotiations to actually accomplish that. And finally, the court says the defendant has offered no evidence whatsoever showing that there is in fact any intention to engage in the forestry business. And the court didn't hold that forestry isn't a business. It said forestry is not a business that's fulfilling the purposes of this LLC. And apparently that's because the managers, at least since 2022, haven't been able to agree on how to move forward. So he eliminated both forestry and the real estate development in terms of what was feasible to move forward.
Does the conclusion that this is meets the legal standard for dissolution, that it's not practicable, does that require us to accept, I guess, as an uncontested fact, since this is summary judgment, that selling the property is the highest and best use that fulfills the purposes of the management agreement? Because suppose there was some other use. Suppose your client wanted to do something different, and there was just a reasonable disagreement about which was the most in line with the operating agreement. Would that still mean it's not practical? And the concern here is, what implication does this have for all other LLCs, where someone might say, I want to do this thing with the property. You don't agree with me, so therefore we get to dissolve.
Justice Earls, I actually see this, and I think the court saw this in 2 parts. The first part is, are the uncontested facts show that they haven't moved forward and are not likely to move forward.
But it seems to me that relies on an assumption.
Going to the second.
Okay.
Going to the second part.
Thank you.
Once he decided that, then the statute says we impose upon the court the ability to make a discretionary decision. That is, whether we actually enter dissolution or not. And so it's that second part that the court also exercised and said, yes, under these particular facts and circumstances, not some other facts and circumstances we don't know about, but under these particular facts and circumstances, I determined that it's not practicable to continue, because as I see this was supposed to be an operating real estate business to pass value to the beneficiaries of these estates. And I have determined, as a matter of discretion, to exercise my discretion to grant dissolution in this case. And he could have decided that the basis was there, that it was impracticable, but under these circumstances, he would not exercise his right to order dissolution. It might have been some different factual circumstances that would say, yeah, it's impracticable, but for these reasons, I'm not going to order it. Does that address your issue, Judge?
Well, I think I'm really still at the first stage of what constitutes not practicable. And it seems to me that one man, and, you know, hopefully most operating agreements have something other than just two managers and a 50% requirement for decision. But we're in this world. And it seems to me that it takes something more than just they disagree about what to do in order to get to not practicable.
I agree with that. And that's an issue that the court addressed in the order denying the motion to dismiss. And I would urge the court to look at the order. He spent a considerable amount of time defining or trying to define what practicable meant. He said, we don't have much help from North Carolina appellate cases on that matter. And so he looked at Black's Law Dictionary and then a number of cases in other jurisdictions. And by the way, there's been no suggestion by the defendant that the judge got it wrong in the order denying the motion to dismiss. He set out in that order, if you look at it, that the legal and factual basis for how he was ultimately going to determine the case. And understand that Judge Bledsoe will ultimately determine the case because no one's asked for a jury trial. And if the summary judgment is not upheld and it goes to a trial for the judge, he's already forecast how he would anticipate the outcome for being fulfilled, the ultimate outcome.
As I understood your point, and correct me if I'm wrong here, but I thought that the key point was this is not a case where one manager says to the other, I think we should sell to this developer. And then the other manager says, I don't think we should sell to that developer. In fact, I think I should just buy your stakes. And that's the deadlock. If that was the deadlock, I think this would be a much harder case for your client. But what's happened here is one manager said, there's an offer out there. I'd like to negotiate. We should find out how much it is. And then the other manager said, you know, I'm not going to respond to that. I want to buy you all out, but other than that, you won't hear from me. And that created the deadlock because at a minimum, the business needs to know what some outside party might offer to spend to buy it, and that never happened.
And the other thing, if you put it in the context of the uncontested facts that the court made, that was the end of a process that started in 2018 and 19, where the managers have not been able to agree on any outcome, development, rental, sale, no outcome over a period of years, the culmination being the offer from the third party to purchase.
So in this situation, you don't just have the two managers. You've got 25% interest in the four. Is it correct that the managers have some sort of a duty to the non-manager members to somehow maximize the utility of the properties?
I think, Justice Newby, that's correct. I think that was, if you look at why the LLCs were created for estate planning and what the mandate is in the operating agreements, it seems pretty clear that what these two managers are supposed to do is to maximize the financial benefit to flow to the four members, which are the four brothers. And three of the four brothers want this property, they want the dissolution and want this property to be sold.
And I assume at a dissolution sale, there's nothing to prevent any of the members from participating in terms of being a buyer at that point.
No, in fact, this is not in the record. I don't know if I'd like to respond to the question. Let me put it this way. The court has taken into consideration in its proposed dissolution order being certain that the interests of the defendant are protected and that the defendant will have an opportunity to purchase the property.
It seems to me that there being two non-manager members is significant when you think about the purposes of the LLCs and the responsibility of the managers. Is that correct?
I think that's correct, Your Honor. And again, I would suggest looking at the footnote in which the court says this hasn't been raised as an issue, but I'm troubled by the fact that Manager Charles says that he doesn't feel that there's any obligation for the managers to even consider a sale. And it's not raised here, but that does raise some question in my mind about breach of fiduciary duty. So he had the same concern that you do, Justice Newby. Unless the court has questions, I don't intend to take the rest of my time. I'm happy to answer anything. If there are no questions, then...
This may be a precursor to your partner coming up to talk about forestry. I would like to ask you the same questions or a similar question that I did your friend on the other side, or at least the way I'm understanding what you are arguing. You talk about that the order says that there just wasn't a business of forestry because of the lack of plan expiring and all of that sort of thing. Are you conceding that that forestry is potentially a business of this organization, or a part of the business of this organization?
I don't think it's what I'm contending. I think we have to look at what the court intended in the order. And it seemed to me that he said, look, this came about not because it was to accomplish a business purpose for which the LLCs were organized, but it made perfectly good sense to take the tax breaks that forestry presented. Furthermore, when I look at it, I'm not sure we would call it a business because they really haven't done anything business-like. They haven't had a sale since 2004. They've let their forest management plan expire. They have talked about what might happen in the future, but they have not gotten together to make any plans concerning advancing the forest business. So, you know, I don't know that it was part of the business intended to be, but even if it was, it just hasn't developed. It isn't operating as a business. That's my understanding of what his order, the sense of his order.
My question, though, is more specific to your argument. And so are you basically saying you're not taking a position on whether that was part of the business earlier on before the plan expired and all that? What is your position there? Because the questions that I pointedly asked of your friend was, did that rise to the level of business activity?
It might have been. And again, we don't know exactly what the court would have decided if he had had this decision to make in 2022 before the plan expired. He still could have said, well, the whole purpose of the LLCs was to pass value on, and the purpose of this forestry business was for taxes. And he could have said, and they haven't sold timber since 2004, but he could say, but wait a minute, there's a forest management plan in action, and so I'm going to determine that this was a business and that they were operating it. But he didn't make either of those determinations. It seems to me he says, no, it was not created for the purpose, and even if it were, what they've done or failed to do shows that it isn't being operated as a business. Are there any other questions?
Thank you, counsel.
May I just say that I appreciate my clients and my opponent in the court for permitting me to argue today. This is always a privilege to appear before the court, and I thank you for that.
Thank you, counsel.
May it please the court. Good morning. As mentioned, my name is James Hash. It's also my privilege to represent the appellees in this matter. As my colleague, Mr. Gaskins, alluded to, the business court ruled on what it considered to be undisputed facts, that the business of this, carrying on the business of these LLCs was impracticable. I'm supposed to specifically speak to your honors about the forestry business as it was taking place. And beginning, Justice Barringer, with your question, I think we need to talk about where forestry fits. And of course, our friends from the Forestry Association submitted an amicus brief. So, well, to be clear, we're not asking the court to take a position that forestry as a whole is not a business. I want to be very clear that that's not our read of what the business court's order was intended to do. And we would agree on the whole. I think it's undisputed that forestry itself has economic purpose. But also submit to your honors that this court well knows how to craft an opinion that does not espouse any sort of overly broad sort of proclamation. And instead, any discussion of that needs to be limited to the facts of this case. And here, the facts of this case show there has been a forestry management plan in place. That plan, just for reference, is in the record at several places, your honors, one of which being at R137. I believe it appears at least twice in the record. And that forestry management plan does lay out several activities that took place. But that plan also makes clear that there was supposed to be mature timber ready to be harvested 6 to 9 years from the date of that plan. So there's mature timber, according to this plan, which is the only evidence in the record about this issue, that was ready to be harvested from 2018 to 2022. As the business court found, my colleague Mr. Gaskins already recited to the court from paragraph 8 of the business court's order on summary judgment, in which Judge Bledsoe laid out the undisputed facts regarding timber. It talks about how there is no evidence of an intent to sell timber, your honors. And now there's also record evidence that shows this is notwithstanding the fact that there is mature timber ready to be sold.
But, sorry to interrupt you, but as I understand the amicus brief, part of what they're saying is that the findings that the trial court made to demonstrate that there wasn't ongoing business are true of many other ongoing forestry businesses, that it's a long-term investment, and there may be many years where all you're doing is letting the trees grow.
Your Honor, that point is well taken, and I think it's important to look at. I think it was finding 28, that fateful finding in which the trial court made the statement that there was no evidence of useful economic activity since 2004. And candidly, Your Honor, I don't think that statement was necessary for the trial court to get where it got. And that speaks directly to what we were asking this court to do, is to avoid any broad proclamations about public policy with respect to forestry, or to make any determination that somehow a passive forestry management plan is not economic activity. Instead, Your Honor, we need to focus on, Your Honors, we need to focus on the facts of this case, the overall purpose and intent of these LLCs, and how this forestry plan fits into the big picture. Decide this case on its undisputed facts, Your Honors. That's what we're asking the court to do. And we believe if the court does that, the business court should be affirmed. My time is growing short. May I answer any questions from the court?
Thank you, counsel.
Thank you, Your Honors.
Rebuttal.
May it please court, thank you, Your Honor. And I will be brief. My friend Mr. Gaskins pointed out that section 1.5 of the operating agreement talks about the sale or the development of the property. Let's be clear, that is the intention of both of the managers. It's always been the intention of both of the managers to do so. The trial court clearly focused on the LOI in 2022, and my client's not responding to the LOI. But understand, again, I keep talking to you about the context because I think the context matters. In that context, my client had already said, based upon his experience, that we need a land plan. Somebody needs to do some site planning to put on the ground what can be built here before we know the value of the property. It's not that he wasn't willing to sell. He thought we needed more information. They designated as an expert in this case Frank Leatherman, who is a well-known appraiser in Wake County. He has been in many court cases for the last 20 years. And what he said was the value of this property is somewhere between $5 million and $8 million. How can you get that big a disparity? Because they don't know enough to know. Until you do the site planning, until you do the development, you can't tell what this property is worth. So any hesitation on my client's part to not sell it now is simply because he doesn't know what it's worth because they haven't done the work that they needed to. And I think that's important for the court to consider. Again, my client never said he wasn't willing to sell. What he's saying is we need to do additional work in order to reach that point.
I wanted to ask you about the last thing that came up with your friend, which is that statement the trial court made that since 2004, there hasn't been any economically productive activity on the property. And I think everyone sort of acknowledged, well, that's really not accurate, because with respect to logging, trees just grow and you're not really doing anything. But my question would be, if this was just traditional summary judgment, if the court made a comment like that in its reasoning, we would just disregard that because our review is de novo. But I think your position is, this is a discretionary decision. If it looks like something the court considered in its discretion that it should not have, we need to send it back to the trial court to reconsider it without the improper reasoning.
No, I do
That's your
think that,
position here of what we would,
yes, sir.
what the remedy would be.
No, I think that's right. And I think that again, that the court only looked at part of the record when it made its decision. And our problem with the court's decision is there's clear evidence to the contrary. All right, there's no clear evidence of any deadlock that should result in the dissolution. Again, going back to dissolution is the death knell for these LLCs. Well, what's the standard for not practicable? At what point should the courts get involved? It's interesting because the trial court jumped to the conclusion that because they haven't hired a forester, they're not going to hire a forester. Well, I'm not sure that that necessarily follows, but clearly it's a fact question as to whether or not they're going to do something like that. The fact that they poorly executed the forestry plan doesn't mean it wasn't a business. All right, our contention is it is a business, and the trees continue to grow to this day. And that is economic activity. They haven't realized it. They haven't turned it into anything. But the fact is the trees growing on the land is in itself, in our view, economic activity.
And what's your answer to the argument that there's a fiduciary duty to the non-manager members?
They're clearly, as managers, they have fiduciary duties. And I don't think there's any evidence in this record that either manager has failed to meet that duty at this point.
But isn't the contention that because the other two members want to sell the property, that they have some obligation to honor that?
Given the position of manager, I think their duty is to make the best business decision they can about what's in the best interest of the LLC as a whole, which would include the other two members. I don't think they necessarily have to take into account that those members want something in particular if they think that is not in the best interest of the LLC as a whole. I want to conclude with this. So we're talking about the trial court's order. In paragraph 10, the judge said, beginning in 2018 or 2019, Charles and Jim have disagreed about the use or disposition of the property. That is a far too simplistic statement of the history that occurred here. They've not disagreed consistently between 2018 and now. They've not even taken positions between 2018 and now that are the same. Right? To reach a deadlock, you have to have a position that is my position and I'm not coming off of it. At least that's my view. To have two managers who are saying, well, maybe we'll do this or maybe we'll do that, it does not reach the point of a deadlock where it's not practicable. The fact that they haven't done it doesn't mean they can't do it. And that's our point. No further questions. I'll sit down. Thank you.
Thank you, counsel. Thank you both. Mr. Clark.
All right. Yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state.